Time to check in with Chris Dimakos. He is our CJAD 800 legal contributor. And Chris, a big story being talked about now for the past several days, this whole issue with Hockey Canada. 4 more players now having to come forth. Police told them if they didn't, they'd be arrested. They've come forth. Look, there are a lot of legal questions here surrounding this story. Obviously, a lot to cover, but I want to start with number one here. You have now 5 different players. Is this a matter of them all sort of approaching this individually or approaching this as a group with one set of lawyers? How would it work?
Yeah, absolutely. So when you have cases like this where there's 5 individuals, 5 different set of circumstances, although one event, they almost always have different lawyers. And the reason for that is twofold. One, you want your lawyer looking out for your interests only and not have to look out for someone else's interests, and 2, lawyers don't want to put themselves in a conflict of interest. So for whatever reason, if something comes up that can affect one of your clients and that would prevent you from representing them, you don't want to be in that conflict. So they usually all have their own attorneys. And what they usually do with this case is, first of all, they take a look at the evidence. They take a look at how strong the evidence is from the prosecution. And then they start looking at their client's perspective. So, for example, do they have an edge here, even if it means breaking away from the other 4? Is there something that their client has in terms of circumstances that they can use to acquit their client or exonerate their client? So at the beginning, it's a lot of questions. It's a lot of reviewing the evidence. And then they start forming a strategy, which many times means breaking away from what the general strategy is of the other 3 or 4 or whatever the number is. So it can get pretty nasty in the sense that many people might not be happy with one person taking a different direction, but that's what has to happen.
If this dates back to 2018, I'm wondering if, and we know it's junior hockey players, were any of these minors at the time, and does that change anything?
Well, yes and no, in the sense that if you are a minor at that age, 17, 18, I don't believe they were, but obviously in sentencing it changes things, and sometimes you go through youth courts depending on your age. But for the most part, the accused was not a minor. I believe she was 20 years old, and for the most part, I believe they were all 18 or over at the time. But usually, your age can affect how severe your sentence is. Obviously, the younger you are, the less severe. But in this case, I don't believe there's any minors. When the victim, however, is a minor, it changes a lot of things, and in terms of how severe your sentence is and what the process is. But when you are the accused, in this case, I don't believe it's going to be a factor.
Okay, so let me move on to something else here, because this story, even though this is the latest sort of chapter in the story, we all know this has come up before. Other people had been involved. And there was also, in this particular story, Chris, correct me if I'm wrong, there had been a payment of almost $4 million from Hockey Canada to settle a civil suit. How does that come into play, if it comes into play at all?
Right. So first of all, usually we see the other way around. Right? People get charged criminally, and then if they're successful, they use that to basically fuel their civil suit. And it doesn't necessarily mean that if you lose or someone is acquitted on a criminal case that they cannot be found liable in a civil case. We remember O.J. Simpson, where he was acquitted of criminal charges, but he lost in civil court, and that's because the burden of proof is not as high and strong in a civil suit as it is in a criminal case. So in this matter here, obviously Hockey Canada wanted this to go away. This was not good for the reputation, and they decided to settle it as quickly as possible and not have the whole case play out. And they paid the alleged victim close to $4 million. Now, that being said, will that play a role in the criminal case? Absolutely. I mean, if you are a defense attorney in this case, and you're looking for a motive for, to be able to put forth to the jury or the judge and saying, hey, this person collected $4 million, obviously it's in their interest. There's a motive there behind making sure the story, sticks. And so they're going to be using that. They're going to be using that to basically not paint a negative picture, but at the same time just establish what a motive could be for someone maybe distorting the truth a little bit, and that's going to be talked about. No questions that the defense attorney is going to look at that and try to use that when they're cross-interrogating the alleged victim.
I was thinking about how, one good thing to come out of this big rotten mess is that it's got everybody talking about consent again. And it's been an ongoing conversation. But I know in this particular case that they're saying that consent was given, and that there might actually be a video of the woman giving consent, and yet somehow that might not actually constitute consent if it was considered to be under duress. Can you walk us through this? Why is there a question of consent swirling around this?
First of all, you're absolutely right, and consent has to be. It's something that's not implicit. It's like if you don't say no, then it doesn't mean that you've given consent. Consent. It has to be present. You have to feel like you have consent. And in this case, the video, the reason why it's going to be so talked about is because both sides are going to use the video. The defense is going to say, the players were already worried about somebody fabricating a story, so they had her videotape a sort of consent by saying everything I did here was consensual, blah, 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 blah. And then the prosecution is going to say, well, why did you feel the need to make a video? What about what happened there made you terrified and made you scared that you felt that you had to put her in a position where she had to put it on video? So it's going to be played by both sides. And a lot of times, in these types of cases, the same argument for a same piece of evidence can be, used, and it can be given different perspectives. So in terms of consent, it's the whole case here. Everything that's going to be argued, all of the facts, all of the interrogations, the whole thing is all going to come down to was there consent or not. And the thing here, but which is going to be unique, is that it started off, from what I've read in the reports, this started off consensually, where the alleged victim went with one hockey player to the room, and they're not contesting that there was consent there. The question is following that. So, we have a situation where it's not whether the victim could give consent. They did give consent at one point, and then that consent was apparently did not carry throughout the duration of the night, and that's going to be where the whole case is going to lie on, whether or not throughout the course of that night the players should have known that consent was not present when they went through with that.
So one other question, maybe you can't answer this. So this is a big story. It's getting a lot of attention. It will continue, I guess, to gain attention. How long is something like this likely to go on, Chris?
I think that it can go two ways. If I'm the defense attorneys, you want to look at the prosecution's evidence, and then you're going to sit down with them and see what they're looking for in terms of a plea bargain. And if they can get away with something that is no jail time, and they're looking at maybe some service and therapy, going through some reformative behavioral classes, maybe they'll be done quickly, and the players can get back to playing hockey with the respective teams if that position is still available. But if not, if they feel like the prosecution is asking for too much and the evidence is not strong enough to justify what they're asking for, then it can go on for years. 2 years is not something that's going to be unreasonable in terms of all the examinations and the preliminary hearings. So I would say that it can go on for a long time if there's no agreement.
CJAD legal contributor Chris Dimakos. Chris, thanks so much. Appreciate it.
Thanks, guys.